So an IP lawyer and her husband, who's a startup guy, were getting ready to go on a little road trip to Tallinn. The IP lawyer, as lawyers do, several days ahead of time, you make a little list on your computer in alpha order. You do it by category, like sort of personal things. I need clothes, shoes, workout outfit. Business things, I need to have my cards, I need to have brochure, I need to have the program printed out, other things. You check the gas gauge in the car, you review whether the TomTom has the updated maps and other things. So this is the lawyer part of the marriage. The startup part of the marriage gets up that morning, throws a couple things in a little suitcase, and gets into the car. And so they're driving up and reach the destination safely, and the lawyer, having spent the whole time thinking things like, oh, I remember that one time we drove to Lithuania and the border guards stopped us immediately after the border. Good thing I have my passport. And, oh, I can't remember from the sign if the speed limit is 90 or 100 at this section of the road, and I wonder how much it costs these days. And these sorts of thoughts. The startup guy is thinking totally other thoughts, so that when you arrive at the destination, the lawyer is pleasantly surprised that everything has gone according to plan and well, whereas the startup guy never really had any doubts that everything would go well, and is pleased to go about his day. I can tell you my personal experience is that lawyers and business people see the world differently. And I understand this. I am lucky to live with an optimist who counteracts what is both probably a personal inclination plus professional training to see problems on the horizon, to analyze them from all different sides, and to think about what could be solutions, this is it, before you even get there. Oop, doesn't turn. Preet? Oh, it is. Oh, gosh, I'm sorry. It doesn't go on the laptop. So very briefly, part of what I'm going to talk to you about today for the next 4.5 minutes are sort of pearls of wisdom I have gleaned from quite a lot of work with startups, both as pro bono clients. I am legal counsel to Tech Hub Riga, which means that if you should join Tech Hub Riga, that you can come to office hours once a month, sit, come, talk to me, which means I know ever so many interesting things that I can't talk to anybody about. I'm American origin, requalified in Latvia as both a regular attorney and a trademark and design attorney. And I teach at lots of different interesting places, both lawyers and business people. So what I wanted to give you were 10 questions and answers, which lawyers never give you because the answer is always, it depends. And then 3 avoidable mistakes. So first question, which I have heard from ever so many people in different iterations. Can I patent my nifty idea? Ideas are not patentable. Your way of doing something may be a method patent in the United States, but in Europe, strongly disfavored, probably not. How do I register my software? Maybe in Estonia you guys are more sophisticated, but in my neck of the woods I get this question at least twice a month. Does anybody know the answer? No, actually, no, you can't. You can't. That is actually an equivocal no, or unequivocal no. Do I have to register my trademark? This is a lawyerly it depends. The police will not come and seize you and grab all your brochures and shut down your website if you have not registered your trademark. You do know this, right? But you may well be advised to, at a very minimum, if you have no cash whatsoever, to search and see whether the mark that you've started using is infringing somebody else so that you do not have expensive problems down the road. Number 4, how do I deal with IP on social media platforms? This is becoming, oh, Burton? No, all right, still awake, that's good, thank you. This is becoming more and more of an issue with sharing information, with using names and handles and all these sorts of things, and the principle is first come, first served. The fact that it is your nice trademark that you have even legitimately spent the money for and registered in lots and lots of places does not give you any presumptive right to the Twitter handle, to the Facebook name, to anything else. So get in there very early, also not to the domain, get in there early and assert your rights. What should I put in an NDA? Celia made a reference to this. I think she gave a good description of everything. You really, who was it who said earlier today that there are lots of people who are very paranoid about IP and that you really kind of shouldn't be? You know, when you are helping people with problems having been caused really by the sort of hope and pray method, and you feel very, very bad for them because actually they could have averted this by not having made disclosures that they oughtn't to have made in the context of having some sort of an agreement. So my counsel is, even if you can't afford me or somebody else, get yourself a form, do something to, at the very least, signal to the other side that the information that's being imparted to them is confidential and that they are under an obligation not to tell other people about it. Should I make my programmers sign a non-compete? There are sort of two questions in here. First is, are your programmers working for you or are they contractors? Which is very often the case that they don't belong to you. Little bit tricky to enforce some sort of a non-competition agreement if they're not your employees. So my advice is always to take the people creating stuff for you, particularly if it is ongoing and not just a sort of a one-off project that they're getting you off the ground, and hug them close to your chest in a relationship in which you have some control over what it is that they are creating. So absolutely, you should get your programmers that work for you to sign a non-compete. Yes, Burton? Yes, of course. The fact that you have people working for you and you have created the environment within which they are working. But the thing with contractors versus employees is that, especially in this part of the world where there are employment labor laws which really spell out a lot of duties and responsibilities, you may not have control over things like you may not have control over the actual physical persons in the team programming unless you've spelled it out and remember to put in the contract that they should not change the actual programmers and substitute them without your prior written approval. You may not have control over a situation in which your competitor purchases the company for which those developers work, or that they change ownership or some other way. So if they are your employees, you are at least guaranteed the fact that under the law, everything they produce automatically assigns to you, that you are probably going to be able to deal with the moral rights issues, which are prevalent in this part of the world, everywhere outside the United States, and that they will have a general duty of care to you as their employer. So it's an "it depends" answer. Number 7, how can I protect our trade secrets? This is very obvious. You must keep them secret. If you tweet stuff, if you put it on your website, if you put it in a presentation and present it to people who are not bound by a confidentiality agreement with you, you are going to have a heck of a hard time arguing afterward that they have breached your trade secret, that they have borrowed it and done something bad with it. Does it matter if the whatever it is owned personally by the founders? This is very often the case. Anybody here a person who is the owner of a patent or a registrant of a trademark or a domain name? Even more common. Yeah. Once you get into the stage of the game that you are getting some money and actually kind of formalizing things up, you're going to need to assign everything to your company. Because the fact that it belongs to you, even if you are the only shareholder in your company, does not automatically mean that the company has control over it. Do courts enforce this stuff? I get this question all the time. Well, yes, but see this one, which is certainly the number one question. And as a lawyer and as a human being, what am I going to tell you? Is it going to be cheap or no cost to get decent legal advice? And I think it's the same as is true when you're hiring your development team, when you're hiring the people who are going to help you come up with a beautiful branding strategy. You may luck out and find some fabulous person who will give you advice you can rely on and build your business on for free, but mostly you get what you pay for. That much. That much. So 3 avoidable mistakes. No contracts. I see this all the time. Delightful, smart young team comes, and I said, do you have any papers? No, he was my roommate and his other pal, and they were just kind of all sitting around one night, and there was some pizza and some beer, and they were programming, and oh, get it on paper, at least at some point. Second one, no procedures for managing information. The due diligence binder that was mentioned earlier, this is something you need to start building right away. And the third one is failing to understand the strategic importance of IP. We are all predisposed to think bad thoughts about patent trolls and about all the other people doing sort of not nice things to the flow of information and innovation, but understand that as soon as you are creating anything of value, your competitors are aware of this. They are interested in what you are doing, and if you are very sloppy about all this stuff, you can't necessarily clean it up after you have gotten all that money. So at least have procedures in place and some awareness of what your company's assets are, and you will go very far. Thank you.
Thank you, Ingrida.